So, very good morning to everyone. So, today is our first lecture on contract law. So, the first chapter is on Introduction to Contract Law. So, how we are going to, do our live classes is that I will be reading a passage and I'll explain in my own words, or I may even ask you for, some of the simple questions. So, in between, if you have any questions, you can raise your hand and unmute yourself and you can ask your question as well. So let's begin. So first chapter is a simple introduction to contract law. Here what they have covered is what is contract law in the general sense, and we see few definitions and also what is covered in contract law, where and all contract law applies. And one point I feel like important for exam from this chapter would be regarding private versus public law, and the one key point of how exactly, even though the contracts being private between the parties, but it will also have to adhere to fairness and public fairness and also public policies. So so generally, contract law governs agreements that create enforceable legal obligations. So when we say agreements that create enforceable legal obligations, that's when it becomes contract. Otherwise, simply two parties just promise to each other, that won't be a contract. Contract has to fulfill all the required elements. Of course, in the other chapters, we will see offer, acceptance, considerations, meeting of mind, like that. So many things are there. So generally, contract law governs the agreements. It is governing the agreements that create enforceable legal obligations. So these agreement has to be creating legal obligations. In exam also, that is the main task. We are just seeing whether it is a valid contract. What are the obligations that this contract is going to enforce? It plays a crucial role in ensuring that promises made between the parties are reliable and binding. So, contract law, the law of contract is basically aiming and ensuring that the promises that are made just between the parties are also reliable and binding. It shouldn't be just a simple mere promise, oral promise or written promise, anything it is. It shouldn't be just mere words. It has to be reliable, and parties may be, spending money, doing an action, doing a deal. So basically, they would be acting upon those words. So those have to be reliable and binding. Without the contract law, agreements would lack the certainty and trust necessary for personal, commercial, and public interactions. So without such reliance or binding of such statements or promises, that would certainly, it will take out the trust factor, and that is which is required for personal, whether be it personal contract, commercial contract, or even public interactions. Let us see the definition and purpose. Contract law has been described as an affirmation of the human will, an affirmation of the human will to affect the future. So today we are discussing about, today we are, entering into a contract. We are not only dealing with what we are going to do today, we are also covering what will happen in the future, what I should do as a party in the contract, what you should do, what are your obligations, what are your rights, what are my rights and obligations. So we are affirming, we are confirming human will. So both are humans, our will to affect the future. It is going to be enforceable and affect our future through the extraordinarily powerful mechanism of protecting exchange into the future. So this definition is given by McNeil in the book called The New Social Contract, 1980. So you can use this definition in case if you get any question in between while filling in the gaps or in the introduction part, you can mention. But direct question on theory might not be, specifically a direct question on what is the definition of contract, of course, but this is for our understanding. It provides a framework that allows parties to form, execute, and remedy breaches of agreements. So, contract law, when we say contract law, it is a framework that is providing and allowing the parties to form an agreement, execute that agreement, and remedy breaches of those agreements. Hence, it is becoming a contract. Contracts are the agreements that is enforceable by law. Now, what is the importance of contract law? So there are two importance. First one is practical utility. As we see in everyday activities like buying goods, signing a lease, or agreeing to any services, we enter into a lot of agreements in our day-to-day life. Even when buy any phone, you enter, you turn on your phone and a lot of things come up, and you'll be like, okay, here I agree and continue. I agree and continue. So even though there also, even you read it or not read it, you are entering into those contracts. You are accepting those privacy policies, everything. So even there, or even buying goods, signing a rental agreement, you're purchasing a house, you're leasing out a property, anything. All these are governed by our contract law. So these are practical utility of contract law. Now, what are the broader application? Second aspect is the broader application in the, you can say, in the business and real estate law and even employment law. So contract principles are also foundational in other legal fields like business law, such as mergers and partnerships. These are dealing with, more of commercial, you can say, commercial side of it. So first one is the practical utility, that is everyday activities. Second is specific in certain legal fields such as business law, real estate law, employment law. There is also overlap between private and public law. Let us see how it happens. Although contracts are often seen as private agreements because it happens between two individual parties, right? It may be two persons or legal entity also, but it happens between private parties. But they do have significant implications for public governance and societal values. Now, how does that happen? When we are dealing with any law, imagine there is this now, for example, okay, let us take only contract law example only. One case happens, okay, one issue happens out. Yes,
there is a customary practices, ma'am, also in some specialized contracts like marriage
mm-hmm. Yeah,
or subtender agreements
yes,
that can be a very good example for the private agreements, or because when there is no government entity entitled with the other government entity, and other private persons also indulge in that.
yes, exactly, it becomes a customary practice, and it will be also, affecting. Yes, that is a very good example for private law becoming, affecting the public governance and societal values. Of course, that is very good. So when, even though it is between two private individuals or two parties or two more than two parties, so it will be affecting in the longer run. If it will be affecting, whatever is upheld in that contract will be affecting the other parties also. So so the courts in the earlier days, what used to happen, courts used to accept the contract as it is in the very earlier days. But later, when they saw the implications that it had on the society, then they started scrutinizing the contracts, scrutinizing the terms of the contracts, and then they started invalidating such terms, and which are against public policy. such terms which are, one-sided contracts, and which is basically one party is weaker than the other. So they try to protect the weaker party in that particular contract. Michael Rebelcock, The Limitation of Freedom of Contract, 1993, warns the risk of unchecked private agreements. So, in his book of The Limits of Freedom of Contract, he talks about what are the risks of unchecked private agreements. If the private agreements, if he talks about the freedom of contract. Yes, there is a freedom of contract to us humans. We can enter into any sort of contract, but there are limitations on that freedom. Okay, what is allowed without any exceptions or limitations, right? So we do have freedom to enter into contract, but there are limits. We have to fulfill the requirements. We have to be, fulfilling the requirements. Also, we have to adhere to certain limitations. So he says, what are the risks of unchecked private agreements? If political, bureaucratic, regulatory, judicial, or law enforcement officers were auctioned off to the highest bidder, a system of private property and private exchange would be massively destabilized. So what he says here, while private transactions are the focus of contract law, they must not undermine the public policies like anti-corruption measures or environmental protections. For example, bribery in public institutions, if allowed through contracts, would create unfair advantages and erode social trust. So that is also between two parties. No, bribery is also between two parties. So in public institutions, if a person goes for a tender and he, enters into a contract with the public official for bribery. So if that is enforceable by law, if that is supposed to be enforceable by law, it will create unfair advantages and it will erode social trust, because these biddings are supposed to be happening on the fairness. So if bribery being a private contract, if it is enforceable by law, then that would be unfair. So therefore, there has to be set limitations where some agreements are valid, some agreements are not at all valid under the contract law. So contract law helps ensure the agreements respect the broader societal principles. So these are some general things that we are learning from the chapter 1. Public value shaping contracts. Contract law reflects societal values such as fairness, safety, and equality. So what are the public values? It is safety, fairness, and equality. These values influence how contracts are interpreted and enforced, often aligning with democratic decisions. So it has to, just whatever clauses that you're seeing, just focus on whether it is, adhering to public values or not. If you feel one of the clause is not aligning with the democratic decisions such as societal values, it is not being, equal to the parties. There is no equality. There is no safety measures taken in that. There is no fairness. So then that would be against public values. Example of public influence. In labor laws, employment contracts must comply with the minimum wage requirements. So these are the, industry-based examples. So in labor laws, employment contracts will be entered into. If there is no minimum wage requirements, then that contract should not be enforceable, because it is not adhering to the public value, because minimum wage is supposed to be it is universal, right? It is already set in that particular jurisdiction. So in that jurisdiction, whatever agreements, employment contracts are entered into, they have to adhere to those democratic decisions. So these minimum wages and all are decided by the government in that particular jurisdiction. Environmental regulations.
When
Contract.
sometime,
Yeah.
when sometime minister decision override the bylaws of the particularly company bids or tendering projects sometime.
Yeah,
So in
they
that
do.
case, ma'am, there is no freedom of contract, ma'am.
See, minimum wages, of course, it will be dependent on whether it is applied retrospective or not, no?
Yes, ma'am.
Yeah. So today, if you enter into a contract, and next week, if the minister says the minimum wage is changed, okay. So of course, the contract has to be adhering to that particular principle. So you have to enter into a new contract because employment laws are slightly different from the other contracts, right? Because minimum wage is supposed to be applied like as it is for everybody. So if you had entered into a minimum wage, for example, let us say like what is the minimum wage? Like let us say 100 rupees per day. Okay. Then that has to be if it is changed to 150 rupees per day, then I have to pay 150 rupees per day from that date onwards because it will be applying as it is.
Or
And
ma'am.
there will be other terms. You have the freedom to enter into contract, but not with respect to minimum wage, not with respect to some other certainty, because otherwise people will be underpaid, no? And that is against the public policy. That is the limitation of entering into contract. Yes.
Yes, ma'am. Or ma'am, sometimes minister override the some situations that if the person is earning a $15, or sometime minister change the decision and says that if the person is earning below, they will consider it. So this is bypass the bylaw which is mentioned by the ministry of certain departments that you cannot take such type of labor wage. Um, for example, if the British Columbia wage rate is $20 per hour, and the required the person get $17, and the minister interfere in that, and minister says that he has no such type of um, he's not he's agree with that $17. He just bypass all such laws. So ma'am, it is good for that.
Mm, See, if the ministry is saying that is approved, for example, okay. So what happens? Who's the boss here? Judiciary ultimately is the boss, right? So who has to say whether it is that particular minimum wage set by the democratic decision of, okay, this is the $20 you said in your example. So $20 is the minimum wage, but the one of the labor law, I mean employment contract is about $17, right? And finally, now who will be a aggrieved party? Their aggrieved party is the employee, and if the employee goes to court, whether ministry has told $17 is sufficient or not, finally court will decide. The court will see, and court will uphold the societal values because they have to see the ripple effect also, no, like what the effect will happen on the broader jurisdiction, entire jurisdiction. What will happen if they start agreeing for $17, right? So when it is set for $20, the court will finally decide whether it is okay for they have to adhere to $20 only.
Yes, ma'am.
Yeah. Next, we have environmental regulations. Contracts cannot permit actions that harm public resources like rivers or forest. So if people start entering into, contracts wherein the terms are like, okay, you are, uh, you know, um, one particular action will be approved by the contract, that will inadvertently spoil the forest or spoil the river waters. So if it is harming public resources, it is not his private property, right? You can do anything with your private property, but it is not private property, it is public resources like rivers and forests. So that contract cannot permit such actions. That is also against public policy. Then lease agreements must align with laws protecting tenant rights, housing standards. So housing standards also will be already set by the bylaws or in the jurisdiction laws. So local jurisdiction laws will be there for housing standards. So that has to protect the tenants' rights in the tenant rights, when we say, the landlord also will be protected. It is not that only the tenant, it's not one-sided. But when a tenant is entering into a particular lease agreement, it has to adhere to certain standards, housing standards, like house has to be, in living condition, and, it should not be, dangerous for the tenant, and, other rights also, it has to protect the tenant's rights. So these are some three examples, basically, simple examples of how basically public policy influences on private contracts. Now, freedom of contract. The traditional view of contract law centered upon on the principle of freedom of contract. The principle allowed parties to make any agreement they wished, with courts strictly enforcing their terms. However, this strict approach has evolved. So earlier, as I was saying, the parties were allowed to make any agreements that they wished, and courts were strictly enforcing those terms, their terms, those personal individuals' terms. But that strict approach is now evolved. What is the modern shift? Modern shift is towards fairness. Now they look for the fairness and balancing the freedom of making contract with the fairness of, that is, public fairness. So courts now recognize the importance of balancing the freedom with fairness. This shift addresses inequalities in bargaining power and prevents exploitative agreements. So by what is the importance of this fairness? The importance of fairness is it addresses inequalities. As we saw earlier, it is focusing on equality, fairness, and what is the other one? Safety, right? So it is equality, fairness, and safety. So it is addressing inequality so that both parties entered into a contract, both are at the equal footing, not one, it is not one-sided exploitative agreement. So it will address the inequalities in bargaining power. Whatever negotiation happened in the agreement, it both has to be in the equal footing, and also it prevents exploitative agreements, that is, it is lopsided or one-sided agreements. When exactly the judicial intervention happens? Judicial intervention is the court will interfere. When will the court interfere? Court will interfere in the following cases. First, unfair terms. Hidden fees or one-sided clauses designed to benefit only one party. If any unfair terms are there in the agreement, then court can interfere and decide whether that particular term, whether that particular clause is valid or not, whether it has to be severed, whether it has to be, entire contract is invalid, or only that particular provision is invalid, what to do with that particular clause. So that will be decided by the court. Second, exploitative agreements. When one party pressures or manipulates other into signing. So when there is no consent, there is no meeting of mind, there is no agreement between the parties, but the party has, manipulated the other. It may be misrepresentation. It may be mistake. It may be different, reasons. We will see in our different chapters also, specifically for those. But generally, it is exploitative agreements also. The court will intervene. Now, what is an example of judicial protection? A small supplier agrees to a harsh take it or leave it contract with a large corporation. So one side there is a small supplier. One side there is a small supplier. Another side there is a large corporation. If the terms heavily favor the corporation, the court might adjust the terms to render them unenforceable. So it shall not, it is there. See, there is no wrong in favoring one party as far as it is in fairness, right? If it is in fairness, that means the other party has is not exploited in those terms. So if if such, David versus Goliath kind of situation, right? So if it is one side, if it is a small supplier, another side, it is a large corporation, and if that particular and it is a agreement that is harsh, take it or leave it. It is, pushing him to the corner, and in the agreement terms, it is, pushing him to the corner and take it or leave it kind of situation they are creating. So that time, as the terms are heavily favoring the corporation, the court might adjust the terms or render them unenforceable. Either they will adjust the terms, they will do the correction, or they will make them unenforceable at all. In an ideal world, the contracts would reflect equal power and fairness. However, imbalances often occur, and judicial oversight ensures that vulnerable parties are not exploited. So, of course, in the ideal world, it would be, yeah, all equal and fairness would be there. But in real life, we know in reality, it is not so. It will be, having imbalances. And when the imbalances occur, it happens, the judicial oversight will ensure that vulnerable parties are not exploited. So the aim is to protect the vulnerable parties or weaker parties in such exploitative contracts. Then the other part of our first chapter is reflecting on the second chapter. So here they say about talk about indigenous and aboriginal laws in contracts. So how exactly the contracts with or contracts involving indigenous people be enforceable. We will see this topic in detail in chapter 2, but here it is just an introduction. Contracts involving indigenous people are unique because of the historical, cultural, and legal context in which they arise. So, I'd like to ask one simple question. Would you be able to describe who are indigenous people?
Indigenous peoples are the people. They are the first nation people. They came first on that land or that country. So they are totally cut out from the outer world, or they just live their own, or they can cultivate their own food, or they have limited dimensions, so they can behave their cultures, they have different with their cultures or other approaches.
Yeah. Okay. So yes, to an extent, that definition would describe them. But now in the modern world, right? In the modern world, indigenous people are the modern descendants of the people who occupied Canada. So we are talking in the context of Canada. So occupied Canada before sovereignty entered the country, right? So before the sovereignty entered, so the original people of Canada, they are called as Aboriginals or Indigenous people. So now currently who are Indigenous people or Aboriginal people? These are the modern descendants. So this is the definition given by a Delgamove case in 2021, I believe. So it was given by the Supreme Court of Canada. So they say that these are the modern descendants of the people who occupied Canada at the time of sovereignty. And of course, they are distinguished based on their historical, cultural, and the legal context. What is the legal context? We just saw the definition. And the cultural and historical context is that these are the people who are origins of Canada, and they are probably the first people who entered into a contract with the sovereignty, right? Because as you remember, royal proclamation, right? Royal proclamation was entered into with the indigenous people only, so because they were there first and they took the land from indigenous people in exchange of certain acts by the crown. So the courts approach these agreements with indigenous people with special care, balancing the traditional legal principles with respect for indigenous traditions. So, as you might have seen while studying for other NCA subjects as well, be it constitutional law, foundations, or even criminal law, we have seen there is always a special space for Aboriginal peoples. There is always a special, additional layer of protection for Aboriginal people because of the situation that, it has not yet, as you said, they're not completely cut off, not all of the, Aboriginal people, but even today there will be certain bands or First Nations who are completely cut off, but most of them are also integrated into the society also. Now, what is the approach of the court takes it with special care, balancing the traditional legal principles with respect to indigenous tradition. So what are their tradition? We will see that in detail. What do they feel? Because see, in foundations also you might have studied about self-regulation, right? So they have self-regulation. What is self-regulation? They have the independent government, self-government system they have. They have,
Own governing body.
yes, correct, own governing body. So they have their own governing body. They call as band councils, right? And you might have also observed the head of the band is called as chief, right? So they have their own self government, and their own laws will also be there based on their historical and traditional values. So upholding those traditional values, they'll have certain personal laws and traditional values. So those have to be respected by the contract law as well. So these contract law, of course, it is enforceable and applicable to them, but it has to give special leeway or special space enforcing while enforcing the contracts with the indigenous people. We have to look for certain procedural aspects. So special procedures will be put upon, which we will see in detail in the second chapter. Now, what are the key principles of interpretation? First one, contextual approach. Courts interpret agreements involving indigenous people by considering their historical and cultural context. In Satwa Capital Corporation versus Creston Molly Corp, 2014 Supreme Court of Canada 53, the Supreme Court of Canada emphasized that the contractual interpretation involves questions of both fact and law. So it is not just about law, it is also a question of both fact and law while interpreting the contracts. What was the intention of the parties? Whether this particular term has to be held valid or not, they will see fact and law both. Because we know, like in many of the situations, only law will be seen. Some of the situation only fact will be seen. Here it is the matter of both, questions involving both fact and the law. So they will have a contextual approach in interpretation of such contract. Modern treaties. Treaties negotiated between the governments and indigenous groups are treated as comprehensive contracts. These agreements are meticulously negotiated and require respect for their terms. So modern treaties, when you say treaties, treaties are what? Treaties are the agreements that are entered into between the government and the indigenous group. And most of the time when we say indigenous people, it is not individual person, it is a group of their indigenous group. Okay, so that First Nation group. So these are negotiated terms. Treaties are negotiated between government on one side, and another side it is indigenous groups, and they are treated as comprehensive contracts, which means that they have to be seen in a what do you say, like in the overall sense. Okay, in the overall sense. And they have to be negotiated meticulously by requiring whatever terms needed to be fulfilled. As we know, while doing any acts on the Aboriginal land, right? So what you are supposed to do, there are so many requirements under the constitutions also, to be, basic duty to consult and accommodate, all those things will be there. So after duty to consult and accommodate, they may enter into modern treaties, enter into contract. then they form that particular agreement, enter into that particular contract. They call it as treaties, and based on that, the government will then carry on those particular activities. In the case of Quebec Attorney General versus Moses 2010, this case involved a land use dispute under the James Bay and Northern Quebec Agreement. The Supreme Court held that modern treaties are binding contracts, requiring courts to give full effect to their negotiated terms. So, in this case, basically, the Supreme Court was saying about whether modern treaties are binding contracts or not. It is binding contract because if it has fulfilled all the procedural requirements, and if it has fulfilled the procedural requirement that is needed for meeting of mind, agreement between the parties, and having the terms that are fair and reasonable in that particular context, then the court has to give full effect to that particular negotiated terms. Then, as I was saying, they were called as the chief and the band council. So band council authority, who's band council authority in indigenous group? It is a formal band council. It is a formal regulatory authority. Okay, it's a formal regulatory authority in the First Nation. A formal band council resolution is not always necessary to bind the First Nation into a contract. It is not always required, but in some situation it is required, and we will see that in detail in the chapter 2 also. In Kevin Cree Nation versus Kihu Constructions Limited, Alberta Court of Appeal, the court ruled that the contract could be enforceable against the First Nation without band council resolution, provided the council's authority was exercised in other ways. So you can see the band council still has the importance. It has to, still exercise its authority in other ways in order for that particular contract to be valid, in order for that contract to be enforceable. Indian residential school settlement agreements. Do you remember what is Indian residential schools and what happened there?
No, ma'am.
Okay. So in Indian residential schools, incident happened in Canada. So that was basically, the effort of failed attempt of the government in basically, somewhere they did succeed to a level in cultural genocide. Okay. So what did they do? They took the children of the indigenous community and they tried to provide them formal education, entered them into the residential schools. They were not allowed to speak in their own language. They were, many of them, were separated from the children, from the parents. They couldn't even get back to their parents. So, and also there were a lot of atrocities and incidents happened in those schools. So it's not one school; it's like all over, all across Canada. There were like hundreds of schools. Mostly, churches and all those times used to take up the maintenance and regulation of regulating those schools. So that was like huge issue, in Canada. But how did they address it? So later, in the modern days, they have started with the TRC, that is called Truth and Reconciliation. Okay, so commission. So the government has created this commission to basically reconcile with the indigenous people, and they hold, public meetings and conventions where exactly these survivors of those Indian residential schools, and they come forward, they share their experiences, and also on the other side, people who worked in the Indian residential schools also come forward and apologize. So it's basically, what is the purpose of that was, the truth. So bringing out the truth, because many of the modern, citizens of Canada did not know what had happened earlier. So first is to bring forward the truth. Second is to reconcile with the people. So this is the background of Indian residential schools. Okay. So in Fontaine versus Canada, the Ontario Court of Appeal considered Indian Residential School Settlement Agreement a landmark settlement addressing historical injustices against the indigenous people. So what happened in that Indian residential school? After that, they entered into this settlement agreement. Okay, so this settlement agreement addresses such historical injustices that happened against indigenous people, and the court clarified that while Indian Residential School Settlement Agreement had profound societal implication, it remained a contract governed by the objective intention of the parties. What is the objective intention of the parties here? Here it is objective intention of the parties is basically to uh, to address the historical injustices that happened against the indigenous people. So because of that, it still remains a contract. Of course, it has societal implications, but it is still remaining a contract that is governed by the intention of the parties. Then, enforceable promises and remedies for breach. Not all promises are legally enforceable. Contract law focuses on identifying enforceable promises and determining appropriate remedies for breach. For a promise to be enforceable, there are certain requirements. Basically, such as, basic things such as consideration, intent to create legal relations are two basic things, right? So what is consideration? A promise must generally involve an exchange of value to be enforceable. This ensures fairness by requiring both parties to contribute something of value. Something of value. It may not be monetary all the time. It may be service in exchange of a service, action in exchange of an action, or it may be also in exchange of monetary benefit. Now, example, a homeowner agrees to pay $100 to a gardener for mowing the lawn. The money is the consideration for the service for mowing the lawn. Intent to create legal relations. For a agreement, for a promise to be legally enforceable, there has to be intent to create legal relations. Parties must intend for their agreement to be legally binding. So what are the intention of the parties while agreeing into those terms are also important. Example, a business contract typically has a legal force. Non-example, what is not considered as having legal no intention to create legal relationship. A casual promise between friends to meet for coffee lacks this intention. So if you agree with the friend to meet for coffee, and if you don't, that won't be a breach of contract, because it is, first of all, it is not a promise that is enforceable, because it is not having the intent to create legal relations. What are the relations between you and your friend? It's friendship. And in
It's an
friendship,
informal contract.
yes, it is informal relationship. It is not a legal relation. So hence it is not, it is just a promise. It is an informal promise.
Right, ma'am.
What happens if breach, if the terms are breached? When a party breaches a contract, courts determine the appropriate remedy based on the nature of the breach and the harm caused. So appropriate remedy will be given. What is the appropriate remedy now? It may be damages, or it may be specific performance of contract, right? Or it also might be rescission. So damages. Damages are the most common remedy. Most of the time, damages would be awarded so that, it may be, form of shutting the parties, there and solving quick solution. But most
The
of the
other
time,
party get
damages,
compensation instead of that they are getting nothing and they get something. So the
yeah,
party can keep silent for and they can go with the contract.
yeah. So instead of, having a loss, so whatever loss is suffered, so they would be, valued at that particular loss, and that they would be compensated enough for that particular loss. That is true. But in most of the situations, damages won't be sufficient. Okay. No amount of damages would be sufficient. For example, if the situation is of, something, the loss of something that is irreplaceable, that act shall happen. Otherwise, it is irreparable loss. So then what happens? Then it may go to specific performance of that particular contract. The court may even ask the person to, perform that particular specific performance of that particular action they had agreed as per the contract. So, damages example is a seller fails to deliver the goods, causing the buyer to incur extra cost finding the replacements. Damages would cover these additional expenses because he has already found the replacement. So he's just looking for his losses of additional, expenses. So he incurred extra cost. So here damages feels fair, and it is fine. And specific performance, as I was saying, a buyer of rare painting may seek specific performance to receive that particular artwork only. So it's a rare painting, right? So if a party purchases Mona Lisa, there is only one Mona Lisa, right? So there's no like, it can't be replaced by extra cost also, like we saw in the earlier example. So it has to be that particular or specific artwork. So here, it had to be the specific performance only. A remedy where the court orders the breaching party to fulfill their contractual obligation is specific performance. Rescission. Now, what is rescission? Now, this remedy cancels the contract and returns both parties to their original position. Rescinding the contract. You might have heard that particular term, rescind. So it is called rescission. So rescission means it is cancelling the contract and returning the both party. So what were they, before that particular? Where were they before that particular, agreement? So I'll give an example. If when you are entering into a sale agreement to purchase a particular property, so what happens? We usually add a clause over there. So if the due to any unforeseeable event happens, um, then both parties should return back to their original position. Exactly how that happens? In this agreement, the buyer has paid some 3 lakhs amount, okay, and the seller has agreed to, sell this particular property. Now, the original position would be the seller giving back that particular 3 lakhs, no additional compensation, nothing extra, giving back that particular money uh, to the buyer, and also that contract is cancelled, so that the seller also doesn't have to keep his promise of selling that property to this buyer. Okay, so that is, going back to their original position. So here, rescission example here is if a contract is found to be based on fraud, the court may rescind it. So that is done by rescission is the remedy given by the court. Okay, rescission is a remedy given by the court on, if it is found to be on fraud, then the court will rescind that particular agreement at all. Because if it is based on a fraud, misrepresentation, and all those things, then what happens? The contract terms should not be enforceable, right? So the other party, the aggrieved party, will be otherwise in trouble if it is enforced, even in part. So then they have to go for cancelling the entire contract and return them into their original positions. Therefore, in
Ma'am,
conclusion,
Ma'am,
Yeah.
in part performance, there must be some compensation and possibility of the contract some part. Is it right, ma'am?
Compensation
Compensation for the loss.
that
Some
comes
in
under
part.
damages.
So, ma'am, it is part performance.
Part performance.
Ma'am, yes, ma'am. I want to know that. But what is part performance? We're talking about the remedies.
Okay. Part performance would be to do only a partial act agreed in the. Let me give you an example. Okay. Okay. So let us go through an example. So here there is an agreement between the parties. There's an oral agreement between the parties. Alice and Bob. Okay, orally agreed that Alice will sell her farm to Bob for $500,000. Now here, Bob, relying on this particular agreement, Bob is the buyer here. Okay. So Bob, buyer, relying on this particular agreement, pays $100,000 as a deposit to the seller, Alice. He takes the possession of the farm, begins farming, and invests $50,000 in improvements. Example, building a barn. Now Alice changes the mind. Okay, she's going back from the earlier promise. Alice later refuses to transfer the farm title, claiming the agreement is unenforceable because it wasn't in writing as required for the land sales. Now, what happens? Now, in this case, Bob can actually seek the remedy based on part performance because he has already performed, certain actions, right? So he has taken the position, he has given the money, given this portion of the money, like $100,000 he has paid out of $500,000, and part performance he has done, and also has taken the position and he has invested in improving that particular property. So he can show that particular part performances, evidence of that particular agreement he has to show. Then he has to also show that substantial performance has been done from his side, and reliance. Why did he do that? He did that based on the agreement that they had between the two people, right? So the court could order the specific performance here based on the part performance done by the party. So part performance is basically when the parties do something based on the assurances in the contract, and that time the specific performance would be more likely to award than the damages.
Ma'am, with damages, we can avoid recession and we can collaborate with recession or damages. We can give to the other party that who is seeking. So, ma'am, it is good that the person is facing
Hmm.
something happened, like some fraud occurred. So the
Hmm.
other party can claim specific performance plus damages, or we can only give the session.
In recession, will they get compensation? They might get yes, they will get compensation. They can be awarded compensation because there is a fraud, no? So they
Right,
may get
ma'am.
additional damages also. It is not exclusive that if the contract is rescinded, they will not get any compensation. They may get compensation also.
Ma'am, one more question from my side, ma'am. If there is so many remedies in our syllabus, so ma'am, please tell us this. Uh, where we use specific performance, where we use recession, or where we use terminator of contract. or all such types of remedies like injunction, permanent injunctions, or
Yes,
temporary injunction.
I'll show you. There is a cheat sheet that I had prepared for the last batch, actually. Not last batch, I would say. This is my first batch, but earlier there was a student who approached me. So I had prepared this for her. So you can go through this. This is remedy decision cheat sheet while you're, going through the exam. That time you can refer to this. When exactly you have to, give appropriate remedy, and based on what consideration you have to do that. Okay,
Or
so this is,
ma'am, one more question, ma'am. We can give two more remedies simultaneously, or only we can give one remedy.
you can give two if it is going with each other. Like I said, rescinding, that rescission and compensation you can give together also.
Right, ma'am.
Yeah. So this is what I had prepared earlier, but of course we will improve it. Okay. So we will improve this one.
Right, ma'am.
And currently, like, I'll just send this as it is. I want you also to go through this, and we'll improve this so that we can have a proper.
Correct formation of the remedies that, but we can add more in that.
Yes, yes, yes. We can add more, and we will be improving that, so that, for the exam. Basically, my intention of in these classes is not just teaching the, topic, as I was saying, earlier in our call also. So first thing, of course, we need to understand the concepts as it is from the syllabus. Then second step is, equipping you with everything needed for your exam. Right, while you're writing the exam, as it is open book exam, you need to have that quick access to the information. Right, so such tables or IRACs, those I will be providing so that you can, easily answer during the exam and not forgetting any steps. Yeah. So while concluding this particular chapter, first chapter, you can say that contract law is the backbone of legal and commercial relationships, ensuring that promises are reliable, enforceable, and fair. By addressing issues of fairness, protecting vulnerable parties, and balancing private agreements with public values, contract law reflects both individual autonomy and societal priorities. Through its principles and remedies, it provides a structured approach to resolving disputes and upholding trust in legal agreements. So this was a general introduction to our contract law. So more than this, we are going to see in detail. As you can see, in chapter 2, we have in detail understanding of the concept of indigenous people and contracts, how it is dealt, what are the, historical context, what is the um, procedural requirements, and each case actually even given to you in the, IRAC format. What is the issue in that particular case? What was the decision that happened? What was the reasoning? How did they come to that particular decision? Why do we have to go through these cases in this manner? Is because on the day of the exam, it will be easier for you to frame that particular issue. If you can see the similar case in the similar manner, only you can frame the issue in your exam also. Okay. So in this
Yes,
manner,
ma'am.
we will see. So for today, as the first chapter was just introduction, so I want you to go through the second chapter. Okay, so that in
Yes,
tomorrow's
ma'am.
class we would be having, a preview, and you can ask more questions. And in tomorrow's class, we are gonna have 2 hours classes. Okay, today it was 1 hour session. Tomorrow we'll have 2 hour session because we have 20 pages to go through. So
Right, ma'am.
yes, any questions?
Ma'am, so we have a class from Monday to Friday, whole Monday to Friday, these timings, or ma'am, whatever the timings you have provided.
Yeah, so as I shared the schedule in the class, in the group, so you can see we have um, today and tomorrow we have sessions. No? Then after that, next Saturday. So in between the weekdays, what you will do? Weekdays, you have to concentrate on question and answers.
Right, ma'am. So, ma'am, you
Okay?
have provided some questions that we
Yeah.
can sort out.
Yes, I will, because today and tomorrow, whatever syllabus we have completed, we will be completing chapter 1 and 2, right? So I'll be giving questions on based on those so that you can cover those, right?
Right,
So
ma'am.
you can practice on, answer structures. We'll do the basic stuff in the weekdays. So weekdays, of course, will not be having live sessions, but I'll send you, like, we'll be communicating through the group. I'll send you the question, and you can try the answer structure on your own first. Then let me, give you feedback on that, and we'll make the answer structure proper.
Right, ma'am.
Yeah. Okay, then. Thank you so much for attending the class, and I'll see you tomorrow.
Thank you, ma'am.
Thank you.